Information Act of Parliament received assent of the President of India on 15 जून 2005. 15 जून 2005 को प्रेसिडेंट ऑफ इंडिया को अनुमति मिल गई थी. RTI Act 2005 received the President assent on 15 June 2005, came into force in 12 October 2005 to promote transparency and accountability in the functioning of public authorities. Objective: empower citizens by giving them access government information. Significance: instrumental in combating corruption, fostering participatory direct democracy. Right to Information Act was passed in the year 2005. RTI Act 2005 was passed by Lok Sabha on 11th May 2005 and the Rajya Sabha on 12th May 2005. Significance: marking a shift in secrecy of transparency in governance. Impact: empowered citizens to hold the government accountable. Which one of the following statement is true about right to information? It is political. It is a legal right. RTI is a legal right. Grant citizens the legal right to access information from any public authority. Supreme Court ruling derived the Article 19(1)(a) freedom of speech and expression. Fundamental right debate 19(1)(a). Though RTI is not explicitly mentioned in the Constitution, it has been interpreted as an essential part of freedom of speech. भले वो मतलब कॉन्स्टिट्यूशन में मेंशन नहीं है, लेकिन ये एसेंशियल पार्ट है फ्रीडम ऑफ स्पीच का. राइट टू इन्फॉर्मेशन इज ए फंडामेंटल एंड लीगल राइट, दोनों है. ठीक. फंडामेंटल राइट: सुप्रीम कोर्ट हैज रूल्ड दैट RTI is an implicit of Article 19(1)(a). Legal right codified through RTI Act 2005. जैसे पीपुल्स यूनियन ऑफ सिविल लिबर्टीज एंड यूनियन ऑफ इंडिया 2004. कोर्ट हेल्ड दैट राइट टू इन्फॉर्मेशन इज अ पार्ट ऑफ फंडामेंटल राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. इम्पैक्ट क्या हुआ? इंश्योर्स ट्रांसपेरेंट गवर्नेंस एंड कर्व्स करप्शन. RTI and good governance. RTI is a pivotal of achieving good governance as it promotes accountability and transparency. Constitutional perspective: though not explicitly a fundamental right, RTI is derived from the right to freedom of speech. Amendment and controversies. RTI Amendment Act 2019 curtailed the tenure of salary and protection of information commissioners and raising concern about dilution of autonomy. चूँकि अब सैलरी और वो सब अपने हाथ में ले लिया तो भाई ये तो होना ही है. Which of the following terminology is are mentioned in the preamble of the Right of Information Act 2005? कौन सी टर्मिनोलॉजी मेंशन है? तो मेंशन है ट्रांसपेरेंसी ऑफ इंफॉर्मेशन, रिविलेशन ऑफ इंफॉर्मेशन, इन्फॉर्म सिटीजनरी, पैरामाउंटेसी ऑफ डेमोक्रेटिक आइडियल. ये सब उसमें मेंशन है. प्रीएम्बल ऑफ RTI Act 2005: ट्रांसपेरेंसी ऑफ इंफॉर्मेशन, इंश्योरिंग ओपन गवर्नेंस, रिविलेशन ऑफ इंफॉर्मेशन, डिस्क्लोजिंग इंफॉर्मेशन टू कम्बैट corruption, informed citizenry, enabling citizens to make informed decisions, paramountcy of democratic idea, making democracy effective and accountable. These terms emphasize empowerment of citizen, transparency and good governance. Context: the preamble clearly states that objective of promoting transparency while balancing the need for confidentiality with sensitive information. ठीक, with sensitive information. Which of the following is not true about the objectives of Right to Information Act? To empower the women and weaker section of the society. Which of the following is not true about objective of Right to Information Act? To empower the women and weaker section of the society. ये नहीं. टू प्रमोट ट्रांसपेरेंसी एंड अकाउंटेबिलिटी वर्किंग ऑफ द गवर्नमेंट, टू मेक द डेमोक्रेसी वर्क फॉर पीपल इन रियल सेंस, टू एम्पावर सिटीजन्स. ये सब है. द राइट टू इंफॉर्मेशन एक्ट 2005 primarily aims to promote transparency and accountancy, empower citizens by providing access to information, strengthen democracy by ensuring government accountability. RTI Act does not specifically aim to empower women and weaker section. It is a general citizen empowerment tool. Additional insight: empowerment of women and weaker section is usually associated with welfare schemes and specific affirmative actions. Transparency and accountability: correct objective of RTI, making democracy work for people, fundamental principle of RTI, empowering people, women and weaker section, empower citizens, central theme of RTI. Consider the following statement about Right to Information Act 2005. Select one which has not been provided for or is specially exempted. It is not applicable in the state of Jammu Kashmir. हर जगह applicable है. An applicant making a request for information will have to give reason for seeking information. नहीं. Removal of chief information commissioner. नहीं. Every information commissioner can hold office for a term of 5 years or until the age of 65, whichever is earlier. अभी बदल दिया गया है. अरे ये an applicant making a request for information will have to give reason for seeking information. RTI Act 2005 Section 6(2). No reason required. The applicant does not have to provide reason for requesting information. Promotes unrestricted access without fear of discrimination. Current status: after the abrogation of Article 370, RTI is now applicable in Jammu and Kashmir. RTI Amendment Act 2019 changed the tenure of Information Commissioner and central government the power to decide the term. Removal of Chief Election Commissioner provided under Section 14 of RTI. अभी कोई फिक्स वो नहीं है अमेंडमेंट कि कितना वो है कितना नहीं. मतलब चीफ इंफॉर्मेशन अच्छा. Tenure of Chief Information Commissioner and Information Commissioner is 3 years or until they reach the age of 65, whichever comes first. 3 साल अभी हो गया है और 2.5 लाख रुपए पर महीना इनका तनख्वाह है. चीफ इलेक्शन कमिश्नर और इलेक्शन कमिश्नर कितना 2.5 लाख रुपया. 3 साल हो गया है. या तो 65 साल या तो 3 साल. इसमें से दोनों में जो पहले आ जाए. Which of the following section of the Right of Information Act is not related to function and powers of Central Information Commission? Central Information Section 12 deals with the constitution of Central Information Commission, not its function and powers. Sections related to function and powers: Article Section 18, powers to receive complaint and take action. 19, appellate powers. 25, monitoring and reporting by CIC. Objective to ensure transparency and proper functioning of the CIC. 25 क्या करता है? Relates the monitoring and reporting. 19 deals with the appellate process. 18, the powers of inquiry and complaint handling, deals with constitution. RTI 2005 considered a landmark legislation aimed at transparency and accountability in governance. Amendment and issues: RTI Amendment Act 2019 has faced criticism for diluting the autonomy. Public interest versus privacy: balancing the right to know and right to privacy remains a challenge. Supreme Court's stand in the case of Raj Narayan versus State of UP 1976. The court ruled that Right to information is a part of Article 19(1)(a). Utility RTI has been crucial in exposing scams and malpractices like 2G spectrum scam and Commonwealth Games scam. Who Who among the following can impose the penalty under Section 20 of the Right of Information Act? Central Information Commission or State Information Commission? As per Section 20 of the RTI Act 2005, both Central Information Commission and Information Commission have the power to impose a penalty. Penalty imposition: if the public information officer fails to provide information within the stipulated time or malafide denies the request, the commission can impose a penalty of Rs 250 per day up to maximum 25,000 to ensure accountability and compliance in the functioning of public authorities. Significance: act as a deterrent for officials who delay or deny information. In which year was the Central Information Commission established? 2005 में. Central Information Commission was constituted on 20 October 2005 under the Right to Information Act 2005. Objective: to address complaints and appeals related to RTI Act, ensure transparency in governance. Significance: an autonomous body that plays a critical role in enforcing the RTI Act at central government level. Jurisdiction: covers all central public authorities. Function: hear appeal against public information officers. Adjudicate complaints from citizens. Ensure implementation of RTI Act. द टेन्योर ऑफ सेंट्रल इंफॉर्मेशन कमिश्नर अब 3 साल हो गया है या 65 साल के एज तक. अब देखिए, RTI Amendment Act 2019 removed the fixed tenure and allowed central government to ratify the term. Now the tenure is 3 years or 65 years of age, whichever is earlier. Objective of the amendment क्या था? To bring tenure and service conditions of the CIC and ICs under central control. Criticism: seen weakening the autonomy of information commissions. Who among the following can't be the state chief information commissioner or state information commissioner? Legal fields and member of the legislature of the state territory. नहीं भाई, वो ये सरकारी वो है, समझ लीजिए. As per RTI 2005, a state chief information commissioner or state information commissioner should be a person of eminence in public life with wide knowledge and experience in law, science, technology, social service, journalism, administration or governance. Ineligibility: a member of parliament or member of state legislature can't hold this position to maintain neutrality and non-partnership, to ensure the commission remains unbiased and independent of political influence. Helps in maintaining the credibility of the RTI institution. Mazdoor Kisan Shakti Sangathan, a social movement, has been associated with which of the following? RTI Act. Mazdoor Kisan Shakti Sangathan is a grassroots movement based in Rajasthan, founded in 1990 by Aruna Rai, Nikhil Dev और Shankar Singh, to empower workers and peasants by demanding transparency and accountancy from the government. Contribution to RTI: played a pivotal role in enactment of RTI Act 2005. Their struggle for transparency started with demanding records of famine relief, works and workers' wages. Social significance: the movement showcased the power of collective action and grassroots mobilization in shaping public policy. MKSS campaign highlighted social audits and public hearing as tool for citizen empowerment. Additional insights for UPSC, RTI, and civil society. The role of organization like MQSS highlights the importance of civil society movements in shaping progressive legislation. RTI Amendment Act 2019, the changes regarding tenure and salary raised concern about reducing the independence of information commissions. Judicial interpretation. The Supreme Court has reiterated the RTI is a part of fundamental right of freedom of speech and expression. Article 19(1)(a). Good governance. RTI is a integral of citizenship participation, corruption, and enhancing accountability. Which of the following is related to the Right of Information Act 2005? Namita Sharma versus Union of India. Namita Sharma versus Union of India 2012 case is directly related to Right of Information Act 2005. Significance of the case. The Supreme Court directed that the information commissions at both central and state levels should consist of people from judicial background and function in the benches of two judicial background के रहने चाहिए. Function in benches of two members, one of whom should be retired judge. उनमें से एक क्या होना चाहिए? Retired judge होना चाहिए. Later the decision was partially reviewed. The Union of India versus Namit Sharma 2013 case, relaxing the requirement of having judicial members. This case emphasized the importance of judicial independence and fair decision making in information commission. अच्छा, Lily Thomas versus Union of India 2013 related to disqualification of convicted MP MLAs. Nandini Sundar versus State of Chhattisgarh related to Salwa Judum and human right violation. Nandini Sundar. Right to Information Act has in general been responsible for increasing the sense of responsibility in bureaucracy. सही है. It has miles to go to create the desired impact. बिल्कुल सही, दोनों सही. लेकिन इन्फॉर्मेशन वो एक्सप्लेनेशन सही नहीं. द राइट टू RTI Act 2005 increased responsibility and accountability in the bureaucracy by enabling citizens to seek information on government decisions. Despite its success, RTI Act still faces challenges like delays, misuse, lack of awareness, and threat to RTI activists. The sense of responsibility comes from the legal obligation of provide information and public scrutiny. Although RTI has brought positive changes, it is yet to be fully realized its potential due to implementation gaps. The objective of the Right to Information Act is to secure access to information from public authorities. Secure access to information from public authorities. Secure access to information from public authorities. The Right to Information Act 2005 aimed empowering citizens by granting the right to access information under control of public authorities, promote transparency and accountability, empower citizens by allowing them inspect government record and obtain copies of documents. Passed by the Lok Sabha on 11 May 2005, Rajya Sabha 12 May 2005, came into force on 12 October 2005. 12 October 2005 में आ भी गया था ये. Which High Court has stated that RTI applicants should tell the reason for asking information under right to information. Madras High Court ने कहा था. Madras High Court observed that the RTI applicant must disclose the purpose for which the information is sought. The judgment was given by the Division Bench Justice N. Paul Vasant Kumar and K. Ravichandra Babu. This view, however, is not an alignment with Section 6(2) of RTI Act, which explicitly states that no reason is required from the applicant. The decision has faced criticism of being contrary to the spirit of RTI Act. RTI Act के स्पिरिट के दायरे में नहीं आता है ये. Which one of the following is not a basic element of citizen charter? Description of services being provided by the department of agency है. Promotion of various methods get benefit from services to expect any public record. Provision from the inspection of the agency's work या नहीं. Citizen Charter aims to improve public service delivery through transparency and accountability. Basic element of Citizen Charter क्या है? Service standards, openness and transparency, consultation and feedback, grievances addressal, choice and assess. Does not relate to the essential element of अच्छा ये provision for inspection of the agency's work ये Citizen Charter में नहीं आता है. At the national level, which ministry is the nodal agency to ensure effective implementation of scheduled tribes and other traditional forest dwellers 2006. तो ये है ट्राइबल अफेयर्स. द शेड्यूल्ड ट्राइब्स एंड अदर ट्रेडिशनल फॉरेस्ट ड्वेलर्स रिकॉग्निशन ऑफ फॉरेस्ट राइट एक्ट 2006, also known as Forest Right Act, aims to recognize and vest forest rights with yestis and other traditional forest dwellers. नोडल एजेंसी नेशनल लेवल पे ट्राइबल अफेयर, ठीक है. Designated nodal agency role responsible for policy formulation, implementation and monitoring the FRA. The act addresses the historical injustice due to forest dwelling communities, ensures livelihood and land security for marginalized communities. Under the Scheduled Tribe and Other Traditional Forest Dwellers Recognition of Forest Right Act 2006, who shall be the authority to initiate the process of determining nature and extent of the individual and community forest right of both. तो ग्राम सभा. Authority to initiate process of determining the nature and extent of individual and community forest right both. ग्राम सभा मतलब ये जो नेचर और मतलब कुछ भी परमिशन लेना होगा तो ग्राम सभा से, वही अथॉरिटी रहेगा. नेचर एंड एक्सटेंट ऑफ इंडिविजुअल और कम्युनिटी फॉरेस्ट राइट बोथ. शेड्यूल्ड ट्राइब एंड अदर ट्रेडिशनल फॉरेस्ट ड्वेलर्स रिकॉग्निशन ऑफ फॉरेस्ट राइट एक्ट 2006, कॉमनली नोन एज फॉरेस्ट राइट एक्ट, empower ग्राम सभा to initiate the process of determining forest rights. फॉरेस्ट राइट डिटरमाइन ग्राम सभा करेगा. ग्राम सभा सेक्शन 61 ऑफ FRA एक्ट 2006. Gram Sabha has the authority to receive claims, consolidate and verify them, and then forward the claims to sub-divisional level committee. Sub-divisional level committee फिर as a basic unit of decision making at the grassroots level, Gram Sabha ensures participatory democracy in forest right determination. Basic unit है. अब स्टेट फॉरेस्ट डिपार्टमेंट मेनली इन्वॉल्व इन फॉरेस्ट मैनेजमेंट, नॉट इन डिटरमाइनिंग फॉरेस्ट राइट्स. डिटरमाइन कौन करेगा? ग्राम सभा डिटरमाइन करेगी. डिस्ट्रिक्ट कलेक्टर या डिप्टी कलेक्टर कमिश्नर एक्ट एज चेयरपर्सन ऑफ डिस्ट्रिक्ट लेवल कमेटी. डिस्ट्रिक्ट कलेक्टर या डिप्टी क्या होंगे? ये चेयरपर्सन होंगे, ठीक है. ये जो होंगे वो नहीं होंगे, क्या कहा जाता है, तहसीलदार, BDO, MRO role are more related to revenue and administrative function rather than forest right determination. The act acknowledges the right of tribal communities and forest dwellers, addressing historical injustice. The National Tribunal Act 2010 was enacted in consonance with which of the following provision of Constitution of India? Right to healthy environment constructed as part of under Article 21, बिल्कुल सही. Provision of grants for raising the level of administration in the scheduled tribes under Article 72 नहीं है, ऐसा नहीं. Power of function of ग्राम सभा is mentioned in 2, नहीं ये भी नहीं. ग्राम सभा से क्या मतलब है इसका? इन्वायरमेंट से मतलब है. National Green Tribunal Act 2010 was enacted to ensure the right to healthy environment, which is part of right to life under Article 21. Article 21 recognized by the Supreme Court to include right to clean and healthy environment. MC मेहता केस में. आर्टिकल 275 ये क्या है? 275 क्या है? ग्रांट इन एड फॉर ST एडमिनिस्ट्रेशन, नॉट रिलेवेंट टू environmental issues. Article 243A pertains the powers of Gram Sabha, unrelated to National Green Tribunals. इस्टेब्लिश्ड ऑन एनजीटी 18 अक्टूबर 2010 को इस्टेब्लिश हुआ था। द एनजीटी एम्स टू एक्सपीडिशन डिस्पोजल ऑफ केसेस रिलेटेड टू इन्वायरमेंटल प्रोटेक्शन एंड कंजर्वेशन ऑफ फॉरेस्ट्स। नेशनल ग्रीन ट्राइब्यूनल was established by the गवर्नमेंट ऑफ इंडिया इन 2010 18 अक्टूबर 2010 को to handle cases related to environment protection, forest and natural resources conservation. Established as a specialized body equipped with a necessary expertise to deal with environmental affairs. NGT is not bound by the Code of Civil Procedure 1908, but is guided by principle of natural justice. ये एकदम एनजीटी बाउंड नहीं है सिविल ऑफ कोड प्रोसीजर से, लेकिन ये प्रिंसिपल्स ऑफ नेचुरल जस्टिस से वो है। मतलब ये अपने हिसाब से वो करता है। विद इन हाउ मेनी डेज एन अपील कैन बी मेड एन एग्रीव्ड पर्सन बाय द डिसीजन ऑफ द नेशनल ट्राइब्यूनल ऑफ द सुप्रीम कोर्ट 90 डेज 90 दिन के अंदर। अकॉर्डिंग टू नेशनल ट्राइब्यूनल एक्ट 2018 ग्रीन ट्राइब्यूनल 1918 अपील कैन बी मेड टू द सुप्रीम कोर्ट अगेंस्ट द डिसीजन ऑफ एनजीटी विद इन 90 डेज फ्रॉम द डेट ऑफ कम्युनिकेशन ऑफ द ऑर्डर। The tribunal has the power to review its own decision, but if the review fails, the appeal lies with the Supreme Court. By 90 days, this period ensures a reasonable time frame for the aggrieved party to seek legal recourse. Which of the following statement with respect to the Land Acquisition Act 1894 is not true? Land Acquisition 1894 क्या पूछ रहा बताइए। It was made by British rulers, सही है। Its purpose was to help the process of land reform in India. कब से ब्रिटिश लैंड रिफॉर्म करने लगे, गलत है। It has been replaced by another act of India's parliament. हाँ भाई 1894 का एक्ट कब तक चलेगा। Its implementation had become disputed, बिल्कुल सही है। Land Acquisition Act 1894, the British government 1 March 1894 to acquire land for public purposes, primarily for infrastructure and industrial projects. Not aimed to land reform but to colonial administrative control. The right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 इससे रिप्लेस किया गया। ठीक, issued with implementation the act faced criticism of being unfair, exploitative and outdated, leading to protest and disputes. The new 2013 act focuses on fair compensation, rehabilitation and consent of affected families. ये सब चाहिए होगा। Which of the following labor related acts have been amalgamated into the Code of Wages 2019? मिनिमम वेज, बोनस नहीं, अरे बोनस भी, कॉन्ट्रैक्ट लेबर, ये कॉन्ट्रैक्ट लेबर एक्ट इस पैसे से जुड़ा नहीं है। इक्वल रिम्यूनरेशन एक्ट सही है। कोड ऑफ वेजेस 2019 कंसोलिडेट एंड रेशनलाइजेज द प्रोविजन ऑफ फॉलोइंग 4 लेबर लॉज। कौन कौन सा? द पेमेंट ऑफ वेजेस एक्ट 1936, मिनिमम वेजेस एक्ट, पेमेंट ऑफ वेजेस एक्ट 1936, मिनिमम वेजेस एक्ट 1948, पेमेंट ऑफ बोनस एक्ट 1965, पेमेंट ऑफ बोनस एक्ट 1965, इक्वल रिम्यूनरेशन एक्ट 1976, इक्वल रिम्यूनरेशन एक्ट 1976, पेमेंट ऑफ मिनिमम वेजेस एक्ट, पेमेंट ऑफ बोनस एक्ट, रिम्यूनरेशन एक्ट। अच्छा, मतलब एक्स्ट्रा पेमेंट। द कॉन्ट्रैक्ट लेबर रेगुलेशन एंड एबोलिशन एक्ट 1970 हैज़ बीन सब्सम्ड अंडर द कोड ऑफ ऑक्यूपेशनल सेफ्टी हेल्थ एंड वर्किंग कंडीशन 2020। ये लेबर वाला इसमें आ गया है। और सिग्निफिकेंस ऑफ कोड ऑन वेजेस इंश्योर्स यूनिफॉर्मिटी ऑफ वेजेस फॉर ऑल एम्प्लॉयज इन बोथ द ऑर्गेनाइज्ड एंड अनऑर्गेनाइज्ड सेक्टर, प्रमोट द कंसेप्ट ऑफ मिनिमम वेज एज ए यूनिवर्सल राइट। ठीक, तो ये हो गया अपना। ठीक है, अब ख़त्म करते हैं, बाकी अगले में मिलते हैं हम लोग। थैंक यू, बाय बाय। ये 70 से लेके अभी कितना बचा है? 17 क्वेश्चन और बचा है। ठीक है, कल नहीं आ जाएगा। थैंक यू, बाय बाय।